morning here where I am and when I am, but whatever time of day it is and wherever you are, I hope it's a good one. And I hope you are looking forward to the last of these little lectures for this week, when we're going to explore the ways in which the online dispute resolution and robo-judges intersect with some of the ethical issues that we've been thinking about over this semester. Just as a quick recap, you'll remember that online dispute resolution is a phenomena that emerged in the 1990s, essentially as a branch of alternative dispute resolution. At the time, it was really just a subset of alternative dispute resolution in electronic form, and of course there were many different things that fit within the scope of our idea of online dispute resolution initially. E-mediation, e-negotiation, e-arbitration, put an E, like Beyonce sings, put an E on it. Okay, that was just completely inappropriate, but there you go. So the idea effectively was to find ways that didn't require people to be meeting in person to undertake a mediation or a negotiation, and but electronic dispute resolution processes or online dispute resolution processes have evolved into something significantly more than that. And the question we're really asking ourselves is, can we imagine a court, as in the service that a court provides, being provided without the intervention of humans at all? Can we imagine a world where we have robo-judges, and what would that look like? Where would we draw the line? Well, would we draw a line where we would need humans involved at all? And if so, and I think the answer to that is likely yes, that there are some things that culturally we will never be comfortable with just being decided by a machine. Those of you who've seen Minority Report, again, all my pop culture references date me. But, that's the kind of thing science fiction is made of, right? That no human intervention in decision making. So, look, let's get stuck in. There are three key areas at the high level. So if we're talking about our moral position, our ethical lens, as opposed to the codified ethical rules that we see in the Australian Solicitors' Conduct Rules or the Barristers' Conduct Rules that we'll keep referring back to, the three high-level questions that we're going to really be looking at is the impartiality of decision-making, the fairness of the process, and cost. Is there a way of reducing cost in some way, probably in the broadest possible terms? So in order to really kind of focus in on this, actually before I go, I've just noticed what I put on the heading here. I've used this heading OADR, so online alternative dispute resolution. Now here really what I'm trying to distinguish between is the idea of online dispute resolution, so online judging, as opposed to the use of online techniques in non-traditional court dispute resolution processes. So in ODR, in its broader sense, we can imagine ultimately the idea of a robo-judge, where an online dispute resolution focus, the emphasis is on the dispute resolution. So we're talking about ways of using technology to assist people to resolve their disputes. So a subtly important difference. Don't worry, I'm not going to examine you on the way that these terms are used. They are not terms of art. That's just the ways that many academics and in the readings that you have, the way that those terms are used. And that's why I wanted to point them out. In an exam or an assessment context, you are always going to write out what you mean in full and use your acronym consistently afterwards so that you've set how you're using that term in a defined way. So in order to really think about these high-level ethical issues, I think we have to answer the question, what does it mean to have a fair trial? What does a fair trial look like? Victims of crime, families of victims, friends of victims, people who are aggrieved or have been wronged in some kind of civil dispute, they may feel shortchanged if there is a lack of physical connection. It goes back to this question of what is a court for? Is it necessary to look the accused person in the eye? Is it necessary for a fair trial to have your day in court? It's going to be really important for any kind of successful online dispute resolution system that the users of that system have trust and confidence in it. And a key element of that will be that it is and is seen to be an impartial system, that it doesn't favour some over others. One of the key concerns initially here was around technical literacy. Is it he or she who has the fastest computer wins? It's going to be really important that any kind of pervasive ODR system needs to be usable by people who aren't necessarily at the high ends of the technical literacy scale. Okay, but sorry, back to impartiality and neutrality. Courts have addressed the need for neutrality by requiring judges to be impartial, to sit in public, to have open trials, to provide their reasoning, and ultimately to be subject to appeal. So it's natural to think then that an online dispute resolution platform needs to employ similar protections suitable for context. The question that I would always ask is, though, in order to achieve the outcome, impartiality and transparency, does it need to be done in the same way? One of the issues that we have been grappling with over the course of this semester, particularly in the first half of the semester when you were doing a lot of reading about artificial intelligence in particular, and let's face it, a non-human judge is likely to fall within the scope of our idea of artificial intelligence. So a non-human judge, when we're thinking about artificial intelligence, one of the issues we've been grappling with is this black box, this lack of transparency, this lack of ability for us to understand how decisions are made, what factors are taken into account. And so will it be necessary for any kind of AI that achieves judgment status to be providing its reasons in the way that judges provide their reasons? Clearly, judges don't provide all of their reasons. Judges are human, and some of the benefits of human beings are emotion and attachment and understanding of culture. And some of the negatives around having human being judges are emotion and bias and understanding of culture. When we think back to many of the decisions that have shaped the nature of commercial law, there are many of them that maybe would have been decided differently in different times or different circumstances. So I'm thinking particularly you've all done contract law, when we think about the element of contract where there is a requirement that there's intention to enter into a legal relationship. The early cases in relation to that, particularly when we're talking about whether or not it was a family or a social relationship as opposed to a company or a commercial relationship, they involve essentially husbands and wives, and they very much reflect what is now, thank goodness, a very outdated way of understanding the family in a very European, well, actually British context initially, and really it was about the, effectively wives usually not having either capacity to contract or probably more insidiously in a way, that it was thought that any promises that a husband made to his wife weren't necessarily binding because there's no intention to make them a legal relationship, that actually these solemn promises it was somehow outside of the law, which is really a reflection, when we think about it, of the culture and the bias at the time. Now, no judge in any of the judgments said, well, this is basically what our understanding of the family is. We think that the promises that are made to wives aren't as important as promises that are made to business colleagues. But there was a cultural understanding there. There was a black box, in other words. Now, we've been able to evolve from that. If an artificial intelligence is making a decision with that same kind of black box, but whatever the issue happens to be with them, it'll be really interesting to see how that gets unpacked. Some of the ways that the academics have talked about dealing with bias in particular could be that there may need to be ethical requirements for programmers, that there may need to be some kind of like versions of Asimov's laws built into the systems from the very beginning. Some sort of formal accreditation maybe that requires those people or those entities that provide online dispute resolution or online alternative dispute resolution, that ensures that they have some kind of impartiality before their accreditation. Or there could be a matter for the marketplace itself, with disputants ultimately would favour, in theory, the platforms that are more trustworthy or fair. When PayPal solved, quote unquote, the problem of trust, it actually became an incredibly profitable and important business on its own by offering a dispute resolution mechanism that was transparent, fair, trusted, low cost. Now, I'm loath to recommend more reading because I know how much reading you have generally, but particularly in this subject. But for those of you who find this kind of interesting, a little bit of procrastinator reading, Malcolm Gladwell, a British journalist, and I think we might even call him a philosopher, in his relatively recent book, I think it came out 2018, 2019 or so, it's called Talking to Strangers. He's got a really excellent chapter on judges in particular. So the book itself is about why it is so difficult for people who are in different cultures or in different circumstances to really speak and listen to each other in ways that they can understand, and really connect with each other, but in this really broad-reaching way. Gladwell's a great writer, and he deals with some really interesting subject matter, and if you have the time, it's absolutely it's a good holiday read. But one of the chapters in Talking to Strangers, he looks at the difficulties that judges in the US have when they're making decisions in relation to giving bail. He highlights that because judges are human, they have a propensity to make bad judgments, effectively, about people's character when they're faced with strangers in a courtroom. He looks at some artificial intelligence that's been designed to make decisions about bail applications as well, using a database of more than 500,000 cases. So the computer itself, or the AI, was fed with the details of the accused age and criminal record. The point of the exercise was to determine whether the judge was more or less precise than the AI in judging an accused person as being high risk. So effectively, high risk meant in this context, would they or would they not commit another crime when they were out on bail, or would they skip bail, basically? Or so clearly, everybody who goes to jail, theoretically at least, they're not committing new crimes, and they're definitely not skipping bail. But a high proportion of people who are granted bail might commit another crime, or they might skip bail. So effectively what they wanted to test was would a machine have a lower percentage of people that it released on bail that skipped bail or committed another crime compared with judges? Ultimately, and probably not surprisingly, machines win and man loses in this situation. The AI was significantly better at predicting which accused people were high risk. So why I point this out, and there's been a lot of experiments like this, is predictive justice can play a really important role in assisting judges to make accurate decisions in ensuring the administration of justice works out for all fairly and efficiently. The trick is, and we've talked about this in previous sessions, the trick is training the AI. And so rubbish in, rubbish out. So we've also seen instances where the AI has picked up inefficient predictions as a consequence of inbuilt bias. But that bias ultimately comes from the humans. So thinking about the ethical issues at the initial part and finding ways to deal with that are really, really important. And actually, I'll skip to the next slide to talk about the last two blocks here, conclusion and cost, because I think even though we're talking about cost we can think about in two ways, and we can think about it in a myriad way, but the two that I want to talk about is cost in terms of time and resources, and cost in terms of actual dollars spent. Now, clearly, the longer it takes and the more resources you use, the higher the dollars are. So they're integrated with each other. So I mentioned Aon and ANU in one of the earlier lectures for this week, and we've got a couple of elements from that case, or in particular a quote actually from Sarli and SPC, which was followed in this case by the majority. So that is judges or justices Brennan, Dean, Tooney, Gaudron, and McHugh. And this wonderful quote here: "The mischief engendered by unwarranted adjournments and consequent delays in the resolution of civil proceedings goes beyond their particular effects on the court in which those delays occur." In that connection, there have been a number of cases after Sarli in which there have been accepted, in the context of Judicature Act rules, that the public interest, this is what's important here, that the public interest in the efficient use of court resources is a relevant consideration in the exercise of discretion to amend or to adjourn. So I think I was a bit muddled in the way I was explaining that. In the majority decision in Aon, Sarli was followed, and ultimately these two cases provide authority for the court, for the position that courts need to think about what the impact is, not only on the current case, but on the administration of justice when thinking about discretion in procedural applications. And procedural applications are largely around requests for extensions of time. In dealing with those requests for extensions of time, the court needs to look at the bigger picture and encourage efficient and practical use of the court's time. Many of the reasons why online dispute resolution has become really popular in the places where it has been rolled out, particularly in Europe. So, for example, the Dutch divorce courts, where you can do absolutely everything online now, ultimately stems from speed and low cost. Online dispute resolution might be publicly funded and therefore free or at a minimum price for each user, but it may also just be a volume game like PayPal or similar kind of payment dispute resolution processes that are entirely offered outside of the traditional court system, but provide a mechanism to deal with most of the disputes before they need to be escalated to more traditional mediation, arbitration, or even the court system. And ultimately, the readings that you have will demonstrate over and over again that online dispute resolution, the value that it provides will be central the affordability of online dispute resolution will be central to determining whether it is ultimately seen as valuable and ultimately is used by the people that it is built for. And clearly, just from a straight commercial benchmark, the most financially viable online dispute resolution platform will be the ones that serve high volume, recurring disputes that follow a standard course or pattern. Again, I'm not going to recommend more reading. I've just been having a look at this excellent book, Noah Weisberg and Alexander Hudek, AI for Lawyers, and who doesn't like it with a cheery cover, but they've got a really lovely description here in what they call the Jevons paradox. And essentially the Jevons paradox, which we've talked about in broad terms, is this idea that the more efficient legal work is, the more legal work there will be to do. And ultimately, I see that will apply in the court systems as well. That if we have an efficient, low-cost, speedy way of resolving disputes, more disputes will actually go to the courts, that they are more likely to achieve the outcomes that we have already ascertained that a court is essentially for. The other part of the judgment in Aon and ANU, beautifully written by Justice Hayne here, that I wanted to highlight is the one that's on the screen. I am going to read it for you playing along at home if you're not looking at the slides. A party which has a duty to assist the court in achieving certain objectives fails to do so. A court which has a duty to achieve those objectives does not achieve them. The torpid languor of one hand washes the drowsy procrastination of the other. Are these phenomena indications of something chronic in the modern state of litigation, or are they merely acute and atypical breakdowns in an otherwise functional systems? Are they signs of a trend, or do they reveal only an anomaly? One hopes for one set of answers. One fears that, in reality, there must be another. Interesting, really interesting language, really interesting set of questions, and something that I really think there is value in you pondering on as we move through into the end of the semester. Are we looking at a broken court system? Are we looking at a system where there is this interface where, because it's a club, because lawyers represent themselves and lawyers are the ones who make decisions about the competence and ethical benefits or ethical standards of other lawyers, are we in this torpid languor of one hand washing the drowsy procrastination of the other? Is it time for a massive shake-up of the court system? I'm going to be really, really interested in your views on these, and I think that's something that, hey, if I was you, I would think about in the lead up to the exam. So in also thinking about these kind of ethical issues around how the courts work, your readings from Susskind identify these kind of 4 really kind of more technical tests for thinking about ODR. It would be false for us to claim that barristers and solicitors have now all seen the light and responded positively to the latest proposals for online court. This is clearly not the case, even in the countries where we are seeing online dispute resolution move forward. So what is it going to take for lawyers to adopt and push for ODR? Should they be doing so? Is it a bridge too far? Important concerns have ultimately or have been voiced, for example, over the frequent failures of the public sector technology projects generally and the dangers of lawyers not being involved in legal dispute resolution. are we looking at a need for a total shake-up of the way that decisions that go to court are resolved or adjudicated? Do we need to differentiate between resolution and adjudication at a higher level? And is this a question that needs to be answered by tech people or by judges or some kind of combination of the two? And there really is a kind of legitimate, well, kind of legitimate is ridiculous language, but there is a debate, and it is a legitimate debate over the extent to which conventional hearings might be replaced by ODR. And I think, though, more and more there is an acceptance that there are many decision tree type things that can be replaced by the robo-judges. But there are certain things, particularly those involving somebody's liberty, somebody's access to their children, somebody's ability to continue to ply their trade, to be a lawyer, to be a director of a company, for example, that there is a sense that removing humans from that reduces the fairness. But it's very difficult to articulate, as we're seeing, as a consequence of Moore's law, increased amount of data, increased ability to process that, and more impartiality and consistency in the outcomes from ODR predicted results. AI predicted results. And then finally, whether the resolution of low-value disputes should be settled by online systems that are provided by the private sector or the public sector. So would it be better? Should we be really questioning the way that smaller disputes are handled? To a certain extent, the law has done that. While we all know you cannot contract in a common law system, you cannot contract out of the court system. We cannot have a provision in a contract that says that we disclaim the jurisdiction of any courts. You can include a contractual requirement that you go through a dispute resolution process before initiating proceedings at a court. And we know that in each of the court systems now, the Civil Procedures Acts or their equivalents will effectively be requiring some sort of alternative dispute resolution mechanism before you get any further. So we can see that we could fit a private system, ODR, into dispute resolution, particularly for low cost or low value disputes that otherwise are getting lost in our systems. But there are a number of other issues that are really key here. What about the reliability and credibility of evidence that's taken remotely? One of the biggest concerns, particularly, and it really arose during the pandemic times when we were locked down, is are we at greater risk if somebody is giving evidence online of that person being, what's happening on the other side of the camera? What kind of coaching is happening? What kind of note-taking is available? Now, personally, I think that, many of you will have signed up to Be Real. We know it's not very hard to have two cameras operating at the same time and seeing actually 360 what's going around. We know more and more of you are playing alternative augmented reality games. Those kind of technologies can be brought in, so we could actually have even greater understanding than we ever have of what a witness or an accused connection is to their advisors or to other things that are happening around them. Then again, thinking about Malcolm Gladwell's book and the psychology, what we've learned in recent years about culture and our ability to read people who are not us, we are rethinking what does it mean to look somebody in the eye and know whether you can trust them or not. Current science would suggest actually very little. It is actually very hard to tell whether somebody is lying to you or not. Now, somebody you know well, maybe, but particularly those people who do not behave in the ways one might expect, humans can be very bad at understanding that. Now, most of you will be too young to remember the Lindy Chamberlain saga, which started when I was in high school, but quite famous now. Mr. and Mrs. Chamberlain and their kids were camping at Uluru. It was then referred to as Ayers Rock. And their newborn baby was taken by a dingo. Subsequently, and the body wasn't found, in fact, for many, many years. And in the intervening time, Mrs. Chamberlain was accused of infanticide and ultimately was tried and found guilty, spent a number of years in prison. And one of the key reasons for this is she didn't appear to react when she was accused of this heinous crime in the way that the media and others expected her to. She remained calm, she was very internal, and she was sort of seen as some sort of uncaring person. Now, she probably didn't care about being accused of killing her baby, because she didn't kill her baby. She didn't show any signs of being guilty. There's another even more famous case, I suspect, globally. I'm going to grapple with her name now, but an Italian exchange student, an American exchange student who was living in Italy. Her roommate was brutally murdered, and she discovered the body and then was questioned by the police, ultimately was found guilty by an Italian court, even though there was no physical evidence and not very much circumstantial evidence. The greatest evidence they appeared to have is that when she was captured, she didn't behave like a guilty person. She wasn't shocked enough. She wasn't distraught enough. She wasn't defensive enough about the way when she was accused of this crime. She just sort of seemed kind of confused by the accusations, in part because she didn't do it. So I guess, long story, me getting a little bit off track again, apologies for that. But really, this is about trying to remember that people are not always great at understanding human cues and how humans work, particularly when we're dealing with you on camera, because I'm not looking in your eyes and I can't see that you're getting bored when I waffle on. But I'm almost at the end here. There are also benefits to giving evidence remotely that we should think about, particularly for vulnerable victims. Our children's courts and courts that deal with serious sexual assaults have been using remote witness statements for a very long time, for really, really good reasons. One of the questions that Susskind asked is this one: will the findings or the judgments of a court have less authority? I think that's a really interesting question. I mean, at the moment, we're not really contemplating, even if we go through Susskind's questions about how we would roll out an online dispute resolution process in earlier lectures, it kind of makes sense that the kind of things that we could see happening in the shorter term would be the kinds of matters that are dealt with now at the lowest end courts anyway. So things that are largely procedural in nature that require the following of precedent rather than making precedent. So I guess the answer to that is, for me, is probably, well, initially no, but ultimately the judgments that are made by magistrates also carry less authority than judgments that are made by county court or the Supreme Court and so on. This second last slide here is kind of my model for thinking about this that might be helpful to you. So this is kind of a model that I always, whenever we're looking at really radical change, and people don't like change, right? I think there are 4 things that we always need to think about. When this change occurs, what things will I be able to continue doing that I've always been able to do? So those are things I just don't sweat about right now. What are the things that I can't do now that I will be able to do? They're my opportunities, and I think that's really interesting. what are the things that I can do now that I won't be able to do in the future? Now, in an ODR sense, maybe that is the stuff about the human connection. And what I've been really trying to highlight in this lecture is actually are those the things that we should be questioning generally? When are they important and when are they not? That's something I think we need to be really clear about. And then there are the things that we need to let go. What can't a traditional court do now that ODR will never be able to do either? For me, I think that's really getting into somebody's head. I mean, at the end of the day, we can never really know what anybody is thinking. Sometimes we have difficulties knowing what we think ourselves, much less what anybody else is thinking or doing. We are always going to have standards of proof beyond reasonable doubt or on the balance of probabilities. I can see that we could get much more accurate on the balance of probabilities because we'll have so much more data that will be able to be absorbed into that decision-making part of that analysis part of a decision-making process than ever before. But at the end of the day, reasonable doubt is always going to be a really difficult thing for the courts at all angles. So we need to really think about that. So this model might be helpful for you thinking through your own approach to online dispute resolution. So that's it for today. As always, questions, concerns, frustrations, and of course compliments, share them in the usual channels. And I look forward to our next week, when I'll be going through what to expect on the exam and how to prepare for it. Take care.